Okay, I'd like to call the Physician Assistant Board to order. Today is January 22nd. We are meeting in Sacramento. First order of business will be roll call. Julie Caldwell.
Here. Here.
Here.
Here.
Here. Here.
Present.
Okay, we have a quorum. And there is one order of business, an agenda correction announcement. We have an announcement regarding the petition hearing scheduled at 10 o'clock today. There was a typographical error on the description of the petition on the agenda. The petition that will be heard today is petition for reinstatement of license, not petition for early termination of probation. We will note that for the record, please. Okay, next item of business, approval of the October 30th minutes. Do I have a motion?
I'd like to approve the minutes as written.
Second?
I'll second.
Okay. Further discussion, in the minutes on page 18, line item number 3, paragraph 19, it says maximum presentation instead of maximus. So we'd like to change that if everybody agrees.
So does the first agree to take that amendment?
Yes.
Second? Okay, thank you.
Okay. Further discussion on the minutes? All right, I will call the roll on that. Charles Alexander?
Aye.
Jennifer Calquist?
Aye.
Sonia Early?
Aye.
Xavier Escobar Acosta?
Aye.
Jed Grant?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, item number 4, public comment on items not on the agenda. The board may not discuss or take action on any matter raised during this public comment section that is not included on the agenda, except to decide whether to place the matter on an agenda for a future meeting. Is there any public comment today? Seeing none? Okay. Okay. All right, we will go to item number 5. Educational presentation and discussion of board's role in petition hearing. And that will be our attorney, Christy Slade.
So if I could ask the board members to move into the audience because we're going to have the screen come down. And if you could all take a copy of the handout I provided all of you. So if you want to take notes as we go along and have questions. It looks like this, the PowerPoint. Good morning. Welcome to our discussion about board roles and responsibilities in petition hearings. My name is Christy Shield. I'm counsel for the board. So if all of you could flip to the handout that I gave you, the last page, it's a little easier to follow, I think, with a larger version of this diagram that I have in front of you. So with respect to this area, you're familiar with your disciplinary process. This is kind of a simplified overview. It's a little more complicated, as you know, than this, but the idea is that we have disciplinary matters that come through your investigative process. It's referred to the Attorney General's office, and if they feel charges are warranted and accusations filed, and typically the matter is resolved by way of a proposed decision in a hearing before an administrative law judge or a settlement or default. Once the board votes and there's a decision, there's discipline that's imposed. And in this situation today, we're going to be talking about these three areas, these three items. We're not going to be focusing on everything that went on before that. The focus of the discussion should be on where that individual is today with respect to their rehabilitation. So there are various types of petitions that come before this board, and the law that governs petition hearings is the Administrative Procedure Act, and that's at 11522 of the Government Code and 3530 of the Business and Professions Code. That's a specific provision that governs petition hearings for the Physician Assistant Board. The first type of petition that usually comes before the board is a petition for reinstatement of revoked license. Now, this is also the same procedure that you would use for someone who has a surrendered license. They're treated the same way. Both types of individuals are unlicensed. When they come before you, they're seeking to have their license returned and the right to practice reinstated. There are time frame limitations for hearing these types of petitions. I think the idea behind the time periods is to allow a time for self-reflection and to see whether there have been any improvements in the areas that caused the violation. So for reinstatements, the time period is 3 years after revocation, unless your order that you adopted for the discipline indicates that they can apply sooner. The exception is for people who have mental or physical illnesses, and if that was the basis for the revocation or the surrender, they can come back within 1 year after that surrender occurs or revocation occurs and petition. Now, a lot of people think that it's an automatic process, but simply allowing people to file the petition is what this authority allows you to do. You still have to have the hearing. The second type of petition is a petition for early termination of probation, and this occurs when the licensee is asking that you allow them off probation sooner than originally ordered or agreed. The time period for filing a petition for early termination of probation is 2 years after probation commenced if the probation is for 3 years or more. If it's less than 3 years, they can file within 1 year after probation has commenced. The third type of petition is petition for modification of a condition. This occurs when a licensee is requesting a particular term and condition of probation. They want a relief from that particular condition. And the most common request for relief from an area or condition is typically the removal of the random drug testing condition or abstinence from drugs or alcohol. So those are the most common types of relief that I see for modification of probation. The time period for that type of petition is 1 year after the start of probation. So getting into the role of board members. Has anyone ever served on a jury here? Okay. So the same types of rules apply because what we're looking at is the situation when you have a petition hearing and someone comes before you, you have the Attorney General's office usually sitting on the left side representing the people of the state of California. You have the respondent typically to your right facing you, presenting their case. You have an administrative law judge who acts as like a hearing officer to help you weigh evidence and determine whether some evidence is admissible or not. And then your role is the judge or jury in the case. So the same rules that apply to judges apply to you when hearing cases about neutrality, not being biased. So neutrality, neutral comments and demeanor. It's very important that you keep a neutral demeanor and comments, because the idea behind this inquiry that you're going to be conducting when you're asking questions of the petitioner is, building a record. You want to know what the facts are. Without facts, you cannot have an adequate record to make a decision on the case. So that the inquiry should be very fact-based, based on the documents you've received, the testimony that's been presented to you, and the arguments that have been made. So we ask that you avoid using any antagonistic, patronizing, or laudatory comments. So saying things like, "You're doing great in rehab." That's an opinion. That's not a fact. It's not linked to anything in the record. So it doesn't help with respect to determining whether there's an adequate record for rehabilitation. So instead of saying, "You're doing great in rehab," say something like, "I think it's commendable that you have consistently attended your 12-step program and continued to seek recovery for your condition." Right? That's linked to specific facts in the record. You should also link your questions to facts in the record. So, if it's a reinstatement petition, for instance, "I have concerns regarding the fact that you haven't been in practice for a while. So what have you done to keep current in your knowledge and practice? I don't see any continuing medical education in the record. What else have you done to keep current in the practice?" What factors to consider? So these are the rules governing what you're supposed to consider when you're making that factual inquiry. Business and Professions Code Section 482 requires every board in the Department of Consumer Affairs to develop criteria regarding what is considered rehabilitation evidence. So that same criteria applies to petition hearings. The board's criteria for rehabilitation set forth in your regulations is at 1399.526. So the criteria that are listed there are the criteria that you should apply in every petition hearing that you hear. Here's the criteria that's in section 1399.526. The first is the nature and severity of the prior acts or crimes, evidence of any acts committed subsequent to those acts or crimes, and the time that has elapsed since the commission of those acts or crimes referred to in the first two paragraphs. The extent to which the applicant has complied with any terms of parole, probation, restitution, or any other sanctions lawfully imposed. Now, number 4 doesn't always apply in every case because not every petition is going to involve a crime. And so you'll need to look at the type of violation that caused the discipline to determine whether number 4 applies. Many of your cases may involve patient care, gross negligence issues, in which case number 4 would not be applicable. Number 5 is the most important criteria of the ones that you're going to consider. It's evidence of rehabilitation submitted by the applicant. That is the core of what you're going to be examining, because what we need to look at is who that person is today and what they've done since the violation occurred. So we recommend that you take into account all competent evidence of rehabilitation furnished by the petitioner. Now, this is where your administrative law judge will come into play and will assist with the analysis and review of what is being presented at the hearing, and that the judge will rule on the evidence and determine whether the information that's being provided is admissible or not, will cut off questions potentially that are not relevant to the inquiry, And so that's one of the roles the administrative law judge fulfills to help you analyze what evidence is competent and admissible. The thrust of Business and Professions Code Section 482 is that the board must focus on the rehabilitation and the ability to practice safely. So the ability to practice safely really involves not only maybe physical harm, but also competency. So when you're looking at petitions for reinstatement, for instance, you should be looking at whether you think they're actually be able to re-enter the profession and perform to the standard of care that you require. F, focus on evidence including witness demeanor. This would include the petitioner, and sometimes petitioners will bring character witnesses or other witnesses, or maybe the Attorney General's office will bring witnesses in. You're going to want to evaluate demeanor because it goes to the credibility of the testimony that's being presented to you. You're going to want to look at how they answer the questions, their body language, whether they're candid or not in their answers to you. That information is really critical in analyzing whether that person is rehabilitated. Remember, for petition hearings, the burden of proof is on the petitioner. So if you recall the slide that I provided to you at the beginning with the diagram on it, the discipline process, in that process, the board has the burden of proof by clear and convincing evidence. But when someone comes back and asks for their license back or asks for a term or condition to be, or a probation to be ended sooner, they have a track record of violating the law. So the burden shifts to them to prove and to overcome the presumption that they have that they're not safe to practice. So remember that the burden of proof is on them. So the burden of proof with clear and convincing evidence is that it must establish a high probability of the existence of the disputed fact, greater than proof by a preponderance of the evidence. So preponderance of the evidence is like you probably think they might be rehabilitated, but you're not sure. That is a lower standard of proof than clear and convincing evidence. You have to have high probability that you believe that person is rehabilitated. And if you're not at that level, then they haven't met their burden of proof and the petition should not be granted. So with the different types of burden of proof, we have the lower proof for civil cases in civil court, which is preponderance. We have your burden, which is higher, clear and convincing. And then it's not as high as a criminal case where the burden is beyond a reasonable doubt, which requires moral certitude. So we're not asking for moral certitude, but we are asking that you have a high belief and high probability in, based on the facts and the evidence in the case, that that person is rehabilitated. So what questions are appropriate to ask when you're examining a petitioner? So when, and you're familiar with this probably already, what happens when the witnesses are sworn in and the board has an opportunity to ask questions of the petitioner, what questions should you focus on? So, and what questions should you ask? Now, the first thing we recommend is that you keep the questions simple and to the point, because remember, we're trying to build a clear record of the case. And if you make it complicated and compound and difficult for them to understand, then you're not going to get a clear answer to your questions, and they may be confused about what you're asking them. So if you have a lot of questions, break them up into short sentences and questions, and you have the floor, so to speak, when you're going around and each board member has an opportunity to ask questions. Take the time to think about what you want to ask. I recommend that you, when you're reviewing the petition ahead of time, you write down the questions and then also note questions as the testimony comes in during the hearing. If you're concerned about someone's ability to practice safely, either with or without conditions, one of the things you can do during the petition hearing is ask the petitioner if they'd be willing to accept a license on probation or meet a term of condition of probation before they get their license back, for instance, such as taking and passing the PACE course or undergoing a clinical diagnostic evaluation prior to reinstatement. So even, depending on the type of petition, there's things you can do with respect to determining whether potentially that person could practice but maybe meet a certain condition before they are either off probation or return to practice. Other appropriate questions, like I said before, the focus should be on rehabilitation and the ability to practice safely. One of the criteria that you do look at is the nature and seriousness of the prior act, but I recommend strongly that you don't focus on that prior act and focus instead on what that person has done today. Not what they've done in the past, not what they will do in the future. You only have what's in front of you. And so if only what you have in front of you doesn't show that that person's rehabilitated, our recommendation is the petition not be granted. But explore also their understanding of the misconduct and how they would handle the situation differently today, because part of rehabilitation is self-reflection and understanding what they did wrong and how they would handle the situation in the future. That will give you a lot of information about whether that person's rehabilitated or not. Again, witness demeanor, extremely important in evaluating rehabilitation. What areas to avoid? Now, none of these situations have occurred with this board. I just want to say that disclaimer up front. But areas to avoid obviously are personal characteristics. They're not relevant to whether someone's rehabilitated or not. And so avoid references to ethnicity, race, age, gender, and marital status. Examples, things you should not do are, why would you want your license back at your age? As a female in this area of practice, aren't you in the minority? Personal questions like, how much money do you make and do you live with anyone? None of this is relevant, and the problem with that is that you could subject your decisions to legal challenge because there may be a presumption that you're biased or discriminatory in motive when asking these questions. So sometimes petitioners will volunteer personal information. That's fine. Maybe they're doing it to explain how they were in a bad relationship previously and they're no longer in that destructive relationship. They're married and in a stable relationship. That's fine. They can volunteer that information. But what we suggest is you don't try to elicit personal information about them because, again, not relevant to whether they're rehabilitated or not. Also try to stay away from retrying the original case. That is done. It's over with. Your focus, again, is on those last three areas that we talked about rehabilitation and making a decision and building your record. That's the focus. Who is this person today? Whereas, what happened in the past has already been adjudicated. It's done. We want you to focus instead on who they are, what their plans are with respect to if they're reinstating, what area of practice may they be interested in. That kind of thing is appropriate, but we recommend staying away from the original case. The only value in that is to discuss the seriousness and nature of the offense is something you consider in rehabilitation, but it's really only used as a measure for how much rehabilitation you think may be necessary to meet the clear and convincing evidence standard. So again, when you're assessing the rehabilitation evidence, we recommend that it be a case-by-case analysis. You review the evidence in an objective manner. Look at mitigating and aggravating evidence. So mitigating evidence is evidence that tends to lessen the severity of the issue, and maybe things like providing information regarding the what they've done since that petition issue occurred, and the fact that they have they continuously attend 12-step programs. They're in a stable relationship. Those kinds of things tend to lessen the chance that they may reoffend. Aggravating factors would be things like failure to recognize what happened in the past and have a plan to avoid such recurrence in the future. So those things tend to militate against rehabilitation. Be consistent in the application of the laws and regulations that you administer. So if, for instance, a decision was to potentially reinstate a license on terms and conditions of probation, you should always have with you the disciplinary guidelines, because those are your lawful, legally implemented rules, and those are the ones that govern what standards and terms and conditions you can apply in a probationary case. And staying consistent with those will avoid any potential legal challenges to your decision. The other thing you should always have with you are the factors that I discussed in 1399.526. So those two items are things that you should always have with you when you're reviewing these petition cases, because those are the rules that govern how to evaluate and assess rehabilitation. Resist appeals to emotion. I know that sometimes people get emotional about the fact that they lost their license, but that's not evidence. I mean, what you need to focus on is the fact that they have, taken steps to rehabilitate from that prior violation, and what that may be may vary based on the type of violation that occurred. If it involved alcohol or drugs, you're going to want to look at any of the recovery programs they've taken, if they go to therapy, that kind of thing. Consider only facts contained in the record. So we're in this new age where people like to Google people. And so I strongly recommend that you do not do that. You're required, like a jury, to only focus on the evidence that's contained in the record. I mean, jurors are not allowed to go out to the crime scene and take pictures and interview witnesses and run their own DNA analysis. That is not permitted. You are not investigators. That's another agency's role. That's the Attorney General's office's role. Your role is to receive evidence, to evaluate the evidence, and render a decision. So please do not Google people. If you know the employer where the physician assistant works, do not call the employer and ask them what they think of that person or how they worked with them, or call any of the character references and ask them, whether they understood what he had done previously and that sort of thing. So please stay away from conducting your own independent investigation and focus only what's contained in the record and what you hear at the hearing. The Government Code requires every decision to be based exclusively on the evidence of the record in the proceeding and on matters officially noticed in the proceeding. So that's your limitation with respect to what is in front of you. If you don't think you have enough, that's a clue that the evidentiary burden has not been met. So just consider that. Any questions? Okay, Sonia. Oh, well, no. I think I was trying to explain was that we're right here at the bottom. None of this stuff is occurring when we're dealing with a petition.
Right.
So
just following the map, where does the complaint start?
well, I mean, a consumer files a complaint, or we get a criminal conviction hit on the criminal offender record information that we get from the Attorney General's office. So when people are fingerprinted with the board, we get information that comes in from that, and that in that case the staff will open a complaint to look into whether it's related to the practice and whether there's a risk of harm to the public. You're welcome. Yes.
On areas to avoid, the person has a group or organization that is supporting his license or her license being reinstated. Is that a valid question that we can ask or comment on? That this group is supporting you? Related to race or whatever.
So, I mean, are you talking about an association that supports? I mean, I think it's fine to refer to the fact that it looks like that people in your community are supporting you, but I would stay away from identifying the particular racial characteristic or referring to it in your questioning. So again, I would focus on the facts. So if they give you a letter on letterhead with someone's association and you say, oh, I see that this association has provided a character reference letter, And, can you tell me more about that, maybe? Or, I think that's commendable, and that gives me some hope that, that they're supporting you. I feel really good about the fact that they're supporting that. But link it back to that fact, and the fact is that there is a reference letter in the record showing this particular community organization supports the reinstatement or the early termination of probation or modification of penalty. You're welcome. Yes.
What's the role of a board member if the person is a colleague or acquaintance or a friend?
Yes. Right. We recommend that if you have knowledge, prior knowledge or outside knowledge of the individual, or even if that individual has contacted you, because sometimes complainants and petitioners will contact individual board members prior to a hearing in an attempt to persuade, potentially with respect, and have influence over the decision. And like all of your disciplinary cases, the separation of function rules apply to you still. And just like if you're in a jury, if they questioned you about whether you know this person or if you have any prior history with them, they ask you to recuse, it would be the same situation. Any other questions? Okay, thank you very much.
Good. Thank you, Christie.
Or if they're rain or something. Wow. That noise coming.
Thank you. Thanks.
We might even hire you as our attorney.
This is what I went for today.
Okay, the next item on the agenda, we have the Director of the Department of Consumer Affairs here this morning, Mr. Dean Graffilo. Welcome, and thank you for attending our meeting.
Good morning, Chair Sachs. Thank you so much for having me today. Executive Officers Forsyth, Vice Chair Grant. Such a pleasure to be here. I know it's taken me nearly 10 months in my tenure at DCA to finally formally address the board. I've told other boards, as soon as I get better being at multiple places simultaneously, you folks will be the first to know. Just with the timing of the quarterly meetings, hard for me to obviously get to all of them. First up I want to talk about is the upcoming directors meeting. On the 29th of January, the department will hold its directors quarterly meeting with board and executive officers. These quarterly meetings are an opportunity to ensure that I'm available to hear pressing issues facing the department and its boards and bureaus. And quite frankly, that's why I enjoy coming to these type of board meetings as well. While my time won't allow me to stay here for its entirety, it's a way for me to effectively get a sense of the uniqueness of all the programs specific to DCA. Similar to you, I suspect in order to make an informed decision, you're going to want to get a lay of the land, and no better way for me to do that, in my view, rather than going to the frontline experts just like yourselves. The next item I'd want to discuss is specific to DCA leadership training. The department's future leadership development program and its inaugural cohort continue to make tremendous strides. The FLD mentees, in addition to being paired with a mentor, are participating in special leadership development exercises, working on special projects that will likely have a positive impact on DCA. developing new working relationships, and meeting with several executives who are sharing career advice. I enjoyed being able to spend about an hour and a half with this cohort soon after it first started. I guess it was last fall. The FLD mentees will meet with California Business Consumer Services and Housing Secretary Alexis Podesta, and at the end of the month, Governor's Appointment Secretary Mona Pasquill. Specific to required board member training. Dates for the 2018 board member orientation training have been confirmed. The first one of the year is scheduled for March 21st. The next three will be on June 6th, September 18th, and December 5th. Board members are required to complete the training within 1 year of appointment and reappointment to a board. This is a one-day training in Sacramento which details the important functions and responsibilities of board members. Please contact DCA Solid Team if you're interested in attending. Registration is also available online. I'd be remiss also, you can contact Patrick Lay and Shelley Jones, who are here. They're in our exec office as well. Specific to executive brown bags. Solid has conducted a series of gatherings with board executive officers, bureau chiefs, and DCA executives. These structured social gatherings provide a forum for transferring knowledge, building trust, and establishing network relationships. The next gathering will be on Wednesday, February 28th, and will include a presentation on employee engagement and a formal presentation of FLD's team projects. The next item I want to discuss is specific to one that has been trickling up to me and others, specific to Fiscal. Fiscal is the new statewide system or book of record for budgets, accounting, and procurement that the state of California has implemented for all state departments. Being on Fiscal is part of being part of the state of California family. DCA went live in July of 17, which was part of the third release. While the transition to Fiscal has been challenging, the system is working and capturing all expenditure and revenue transactions for all DCA programs. While implementing the system, DCA has encountered interface and other technical system issues that have hampered our ability to conduct month-end closing process and produce reconciled monthly expenditure and revenue reports. In response to these issues, DCA exec has met with Fiscal's fiscal director and executive team to relay our system concerns and address the technical system issues. As a result, the Fiscal technical team has reached out to assist and are in the process of resolving each issue. In the meantime, DCA's budget office staff can prepare a budget forecast analysis using information we are able to pull from other sources. The budget office has access to expenditure information on the board's salaries, benefits, printing, travel, contracts, facilities, attorney general, and Office of Administrative Hearing costs. These expenditure categories represent the majority of each program's actuals spent to date. These projections can be prepared upon request until the Fiscal generated reports are available for distribution. We understand your concerns in not receiving these reports as they are needed to make important fiduciary decisions. We have made Fiscal leadership, agency leadership, Department of Finance aware of the challenges and boards and bureaus are facing. We apologize for any inconvenience this has caused and appreciate your patience and understanding. DCA is fully dedicated to the cause, and we feel that the expertise to make this transition successful for all of DCA. Again, thank you for allowing me to give this DCA update. I look forward to being able to work directly with each of you as my time forward at DCA continues. Happy to entertain any questions you may have. I'm completely aware of the full agenda that you have before you today.
I have a couple of questions.
Great.
When do you expect that the problems with the budgeting will be resolved?
So, don't have a specific date in line, as you very, very well may know. We are in the middle of budget change proposal season, and come come with them may revise. There may in fact be adjustments necessary. As you may very well know, mid-June is when the legislature primarily is going to have to finalize budgets, and then the governor signing soon thereafter. It's a long way for me to say, hopefully sooner than later, but I do not have a specific date.
And one follow-up question. Did you run parallel systems under the old system and new system before it was,
So,
to see if the new system was actually working?
got it. Not familiar with that. As I alluded to in my brief comments, we are able to assess kind of real-time budget for the board, but I'm not aware of a simultaneous system going directly. I can easily get that answer for you, and my good friend Taylor, who would definitely have that answer, just magically appeared.
Good morning, board members. My name is Taylor Schick. I am the fiscal officer for the Department of Consumer Affairs, and hopefully I can address some of your answers directly. So in regards to the timeliness of actually beginning our month-end close process, I am happy to report that we resolved the interfacing issue with Fiscal last week, and my accounting staff has begun the month-end closing process. And in fact, we just ran allocations over the weekend, so I'm looking for an update on that this week, and hopefully I'll be able to report that we will have closed month one, or what they call in Fiscal period one, this week. Once we've closed period one, we anticipate sort of a waterfall approach. All the information's already in the system. All that needs to happen for us to close month ends is to make sure those interfaces are working, make sure we've reconciled any outstanding issues, and we can start to run the month-end process for fiscal month period 2, 3, 4, 5, and 6. And we're hoping to do that in an expedited fashion. It does take time in the new system, so it's not going to be just, within a week we'll have all of those months closed, but we do anticipate over the next coming months we should be getting closer to a real-time, point-in-time accuracy with these reports. So I don't want to give a timeline now, but I'm hoping by March or so we'll have actually closed all the way up to month 6. But that's going to, we're learning the system, and that's going to depend on a lot of issues during that close process and the running of allocations. To your second question, it's why didn't DCA run 2 parallel systems? That option wasn't necessarily available to us, and there was no way that the Department of Consumer Affairs, with the amount of transaction volume we have amongst all of our boards and bureaus, we didn't have the manpower to run 2 systems. We do know that there are some smaller departments that did have the luxury to sort of run side by side, but the majority are making the transition in whole, so in totality, where CalSTARS is turned off and they're on to Fiscal. I do want to report that all of the transactions, all of your expenditures, all of your invoices are in the system and are going through the system. So one of the things that my budget analyst has been able to do is we're able to pull extracts from the system, compare it to other documents that we're aware of, like our position rosters that have salaries and wages and benefit information, compare them, make sure that the system is tracking all of that information. And so we believe that our forecast, our budget projections are very much accurate. The one thing that's frustrating is it's a new system. It's going to be different in its layout and its look from CalSTARS, and that's one of the issues. Is right now I don't have an ability to roll out those extracts in a user-friendly format to provide to boards. What we're trying to do is hopefully those month-end reports will provide that user-friendly view of the budgets that you're familiar with in your CalSTARS reports, and you'll be able to make use out of them. So, I do apologize for a lot of the frustrations and for, seemingly operating in the dark, but the budget office, the accounting office, we are tracking all your expenditures. We are making sure you're going to stay within your budget, and we are going to be advising your executive officer of any changes that need to be made, or if we think there's going to be an issue coming forward. So I hope that addresses your 2 questions.
Yes, it is. Just one last question. The information we got today, a budget report, says based on fiscal month 5, not actual. So is this a good thing to look at, or can we just
So
ignore
that
it
budget
at this
projection
point?
is a good thing to look at. I actually went through with my budget analyst last week based on that extract. It has the automated allocation figures in it, but it doesn't have the manual allocations yet. But the majority of the costs that are in there, the Attorney General, your salaries and wages, we verified all your contracts and invoices against those contracts. So I believe that is a very good document.
Okay.
Obviously, when you'll look more in detail, there's a couple concerns we have, especially with the year-to-date trend for Attorney General and Office of Administrative Hearings. And we just got their actual reports through January just last week. So those are up-to-date figures with the most timely information that we have available.
Okay, thank you.
And to be clear, Board Member Martinez, I was just about to say the exact same thing that Taylor was going to mention here. In all seriousness, one thing I am learning about DCA is that we obviously have a great staff that assists all boards and bureaus. I'm more than happy to ensure that that communication continues, because as I was alluding to earlier, in order for all of you to make informed decisions, it's important that you have good information.
Thank you.
So Taylor, if I could ask you a question,
Sure.
at what point would we be able to do a augmentation? Because every year for the past 5 years, we've had to do an augmentation to stay above water. I think last year we ended up with $23,000 that we reverted. And I think that's probably one of the big concerns is we don't have real numbers yet.
And so we do have real numbers right now from the Office of Administrative Hearings and the Attorney General, and we do plan to basically put together the package that you're familiar with seeing every year to do a current year augmentation for those costs. Also, we'll be meeting with Ms. Forsyth to go over all the changes that were made for the 2018-19 budget. There was an adjustment made to increase the board's Attorney General and Office of Administrative budget. I don't think, based on the trends we're seeing, that still may not be enough to cover what we're seeing as the over expenditures. But for at least this current year, we do have actual figures through December from both the Attorney General and the Office of Administrative Hearings, which we will be using to basically create that current year augmentation request, which we plan to submit to the Department of Finance most likely by early February.
Further questions? All right. Thank you very much. Thank you, Director, for attending today. We appreciate it.
Thank you.
Gabe was supposed to introduce her new legislative person. Can we do that?
Maybe when we get to legislation.
Well, I'm not.
No?
Next thing is gonna be Kim, or letter, because she's gotta get out of here. So we're gonna move around on the agenda, which I'm famous for. We're gonna go to item number 18, which is report from the medical board. Kim Kirchmeyer, Executive Officer.
Good morning, President Sachs and members. Thank you for having me here today, and also thank you for taking me out of order today and bringing me up on the agenda. Just wanted to let you know that we have been working collaboratively with Ms. Forsyth over the last couple years, but even over the last couple months on a lot of issues that kind of happen between both of our boards, and that is always a good thing to work collaboratively, especially when our licensees work so closely together. And we need to have that open communication between all of us. So I just want to thank Ms. Forsyth and her staff for keeping that collaboration going. So I did want to provide you just a few updates on what's happening with the medical board, and obviously I know that you're supposed to have a member from the medical board on this board, and we're waiting for that governor appointment too. I haven't heard anything about that. I don't think Ms. Forsyth has either, but once that individual gets appointed to the board, then they would be providing this presentation of the board, but for now it's up to me. So just a little bit of what's going on at the board. So some of you may remember that back in 2008, the legislature actually eliminated the board's diversion program. And at that time, we had individuals that were coming to the program that had substance abuse problems, and they were going into our diversion program. That got eliminated. And so from 2008 to really 2016 and even to now, the medical board hasn't had a diversion program. I know the PA board has a program. But then in 2016, the legislature actually passed a bill that said that it authorized the board to have a physician health and wellness program. And so that's something that we're working on right now, is implementing regulations to develop that physician health and wellness program. We're working on regulations that will probably be submitted. Our board approved them at our October meeting, and so we're going to be submitting them to the Department of Consumer Affairs to move through that process. It will not be a diversion program. The only way individuals will be able to go into that program is either a self-referral or be referred to that program from our probation. If we get a complaint, we will still continue through our process, through the disciplinary process if warranted and if substantiated information has been received, and we won't be diverting those individuals and then stopping our disciplinary process. That was one thing that really came out during discussions on this bill. So we will be moving those regulations forward. We will be completely following the uniform standards that have been developed by the Department of Consumer Affairs. It requires that in the legislation. So I just wanted to let you know that we will be going through that process in the next year. At our meeting, the board approved moving forward with the regulations for physician supervision. That's Title 16 California Code of Regulations, 1399.545, which is your physician supervision regulations. So this is where our two boards have a unique interaction, and that regulations that pertain to either physician supervision or scope of practice of physicians do have to go through the medical board. And so our board approved your language that you all submitted to implement SB 337. So that will be moving forward. We'll be working with Ms. Forsyth and her staff to develop those documents that will be submitted to the Department of Consumer Affairs, and obviously Ms. Schild as well, to push those forward through the department and get those going for this board. The board is really working on developing relationships with other boards and state agencies. And in the past, with Ms. Forsyth, we actually worked with the Department of Healthcare Services to have presentations on both what we do as our boards and what they do as their department as well. Our goal is for consumer protection, that we interact with each other and we provide information that they may find where a licensee isn't appropriately doing something. They may be violating the law, and vice versa. We would provide information to them as well. And at our meeting last week, we actually had a presentation from the California Department of Public Health. So they actually provided information on what they do, and now we're going to be working with them to open up that collaboration between our two entities, as well as they go out and do surveys or inspections at hospitals. If they find a licensee that may be violating the law, they would submit that to us, and then as well as us, so when we're going out, if we see a facility issue, we're going to be referring that over to them. We already have that interaction. I think that it's just not quite that everybody understands what the medical board does, just like we didn't understand fully what they do. And so we're opening that communication between us so we can work better with them. Also, at our last meeting, we had a presentation on a survey conducted on the Cures database. This survey was actually done of physicians and pharmacists, and that information was put together by the University of California at Davis, and they provided that report to us last week. Along those lines as well, as far as how we are boards that usually are very reactive to complaints. We wait for the complaint to be received by the board, and then we take action. On this specific issue of prescribing an opioid issue, we actually have taken a very proactive approach. And one way we did that is working with the California Department of Public Health to receive death certificates related to opioid overdose. So we received all of the deaths in 2012 and 2013. And then what we did is we ran Cures reports on those individuals. And then we sent those Cures reports out to one of our experts to review and see if there was any chance or maybe inappropriate prescribing by that physician. If they thought that there was a problem, then we actually are opening up a complaint on those individuals, and we're going to be going through the process. So that was one way where we really thought that we needed to be more proactive than reactive. And so that's a project that's ongoing. Just to give you a few statistics, we received about 2,800 deaths, and we actually only found that about 2,200 of those individuals were within the Cures program. So all those other 600 individuals were either getting opioids via a family member or buying that off the street. And then out of those 2,200 that we sent out, we have about 500 that actually we believe that there could be a possibility of inappropriate prescribing. And so we're referring those out to the field. So that's a big project that we're working on as well. Over the next year, we will also be working with the governor's office on the vertical enforcement model. I know this is something that you guys use as you want to because it's not within your statute. For the medical board, we have to use every case that goes out to the health quality investigation unit for a formal investigation, has to be code worked with the attorney general's office. So the law right now that happened in our sunset bill eliminates that vertical enforcement program at the end of this year. And so there's work with the governor's office on is that the best approach? Do we keep it as is, which is not what the board's perspective is, or do we keep that for certain cases the same way that actually the PA board does? So that's another thing that we're going to be working on. One thing that came out of our meeting last week really was the time frame at the health quality investigation unit. You guys are dealing with that as well because the vacancies over at that department really are impacting the length of time to investigate cases. And so we're going to be doing everything that we can to assist the health quality investigation unit and hoping that those cases and that time frame goes down. So that's another thing that really came out of our meeting last week. The other thing I want to bring to your attention, this may be something you're already aware of, but is in our sunset bill last year, the medical board right now for postgraduate training requirements for our licensees, they either have to take 1 year if they've gone to a U.S. medical school or 2 years is required for those that have graduated from an international medical school. The law last year changed that to where that will be 3 years for all individuals, no matter where they went to medical school. So all physicians are going to be required to do 3 years of postgraduate training. During that time, if they're in California, we're going to give them a postgraduate training license. So all of this takes effect in 2020, January 1st of 2020. So that's something that we will also be working on over the next 2 years. Just one thing, I don't think Ms. Forsyth has spoken about it yet, but we also know that the PA board is currently in the process of having an audit by the Department of Consumer Affairs, and just wanted to let you know that we will be working very closely with her because of our role and our interaction between the two of us and fixing any identified issues that may come up. One thing I did want to let you know we're already working on updating our procedure manuals. I think that will probably be a finding because our procedure manuals, they're pretty up to date as far as the functions. It's just the interacting breeze into those procedure manuals. So that's something that we will be updating. And again, as anything that's brought forward, we will work with Ms. Forsyth to get that moving forward. So again, I just thank Ms. Forsyth and the board for our partnership. And with that, do you have any questions?
I have a question.
Yes.
Hi, good morning. Regarding your postgraduate training program, does that mean that all specialties will have at least 3 years of residency training?
Yes.
Okay, so there's no more GP or that designation?
There will still be a general practitioner. So usually family medicine and general practitioners, they have those 3 years. We're not requiring completion of a specialty program. We're just requiring that they have at least 3 years of postgraduate training. So you'll still have all of the different specialties. An anesthesiologist, for example, will still come in and go through their training. But as soon as they hit that 3-year mark of completing the first 3 years, then they'll have to be licensed. Rather than in the past, they only had to have 1 or 2 years. Yeah.
My second question is that you guys are very proactive on a lot of things in terms of opioid. I'm just concerned that it's taken over 10 years for a diversion program. Can you give some explanation as to why it doesn't seem like it's protecting the consumers? And I just didn't.
Yeah, it was an interesting process to go through when they eliminated the diversion program. At that time, our membership of our board was very, I'm not going to say against a diversion program, but they wanted a diversion program that really was doing the main function of consumer protection. And at the time, the program was within the medical board. It wasn't like, for example, the PA board contracts with Maximus and they provide that. It was actually under civil service, and it was a very hard program to actually have within state service. And so at that time, we had a couple audits that had been failed for consumer protection. And really our board said, we can't continue down this path of what we are. We no longer want a diversion program. We think that there are programs out there that individuals actually will enroll in as they need to. And that has actually kind of been what we've actually found. Physicians that we have that are brought to either a facility's attention or their clinic's attention, they're actually enrolling in some of the, like there's a couple programs out there that are more of a monitoring program. So they've been enrolling in that. But you're absolutely right. You know, our change in membership said probably about 2 or 3 years ago, we really think that for individuals who are substance abusing licensees, they need a place to go to. Our board had actually at that time been wanting that to be outside of the board, that it would actually be an outside entity. And they actually even wanted it so far as that it wouldn't even be within the auspices of the board, except for if they found that there was an individual that was a problem and wasn't maintaining in the program, then they would refer that to the board. As the legislation went through, though, it did put it under the board, but it did say that it would have an outside entity, a third party run that.
So there's no tracking at this point
As far as,
in terms of your physicians who are found to be.
so right now they have to go through the disciplinary process. In 2008, that was kind of what our board said, is if there's an individual that's brought to the attention of the board, we're going to go through and they're going to end up usually on probation. Back in 2015, we implemented the uniform standard. So basically now an individual that we can say is a substance abusing licensee comes in, goes on probation, has that clinical diagnostic evaluation, the substance support group meetings, biological testing, and then abstaining. So that's kind of how they've had it for the last several years, is going through the disciplinary process.
So when they say abstaining, but is anyone checking on them?
Yeah,
or-
because we do biological fluid
Biological, okay.
testing, and then also they also have a worksite monitor that's also for them. So we're doing the consumer protection side. We're just not being that proactive where you're coming from with that early identification and intervention to send them into a program. We're really leaving it on the licensee at this point.
Good morning. Thank you for that interesting presentation. I wanted to ask you, do you have an indication of when the board will appoint someone to the PA board? And do you think the fact that they're a non-voting member may be inhibiting the process?
So unfortunately, it's not for the board to appoint. It's actually the governor's office that has to appoint a member. And so I haven't even spoken with anybody about, I can go back and I can work with Ms. Forsyth to reach out to them and ask. And the voting could have a role in it. As far as an individual being interested in being on the board, I think that could definitely play a part. I know when you guys were going through your sunset, we had kind of mentioned to the BMP office, hey, you know, it would be good if they were a voting member to have them there and, you know, be more interactive and involved. Isn't what happened through your sunset process. It still kept it as an ex officio member. But I think it's just the governor's office is working on all of the appointments. And so this one might be that one that's kind of on hold for right now.
Okay, thank you.
Mhm. All right.
Any
Thank
other
you very much
questions?
for having.
Okay, thank you very
Thank
much, Kim. Appreciate it. I'd like to go back to item number 4 for a minute, public comment for items that are not on the agenda. Gabe Raymond, California Academy of Physician Assistants.
Thank you, Bob. As you may or may not know, Teresa Anderson, who was our public policy director and was with CAPA for 7 years, has left CAPA and moved on to an amazing, wonderful new opportunity. So moving forward, Lynn Andrus is our new government relations director, and Lynn is here today, and Lynn will be here at all the future meetings. So I just wanted to let you know that. Thank you, Bob.
Thank you. Welcome, Lynn. Okay, do we want to break or?
Is the court reporter here? Or do you know if the court reporter's here?
Hmm?
I can find out. Well, I don't know if they need to set up for the hearing or not.
Yeah, that'll take a few minutes.
Do you want to do any of this?
Yeah, we could do, I guess next we're due item number 6, reports. President's report. I just am very concerned, even though we got financial information this morning, we still don't know where we're going to be in April, and I put for discussion consideration of canceling the April board meeting. I really don't want to do that because we have a lot of regulations, I believe, that may be coming,
Hearings, yeah.
and certainly probably some administrative law judge hearings. but I'd like to get the feel from the rest of the members. I mean, we have numbers that were presented to us today, but I don't know how accurate they are. And Dave, you're
I would suggest moving forward with the April board meeting. I mean, it seems to me that with the presentation this morning is we anticipate getting some good numbers in the next couple of months. So I think I would suggest having the meeting.
any other comments?
I mean, if there's any concern, you could move to delegate to the president the authority to cancel the April meeting if there's a budget issue, or to schedule, another option would be to schedule it as a teleconference.
Teleconferences are horrible.
Okay, just throwing it out
Never
there.
work.
Okay.
Okay, well, we will go along and assume that we have money in the bank. Next item will be public comment. Okay, next item will be executive officers report.
Mine's going to be very, very short this morning. First of all, I want to make just a quick comment about our building lease negotiations. It's ongoing. We will have another meeting with DCA, DGS, and the owners the first part of February. Recently, all of the EOs in this building got together with a list of, I don't want to say demands, but things that need to be corrected. It has been sent to the owners. Obviously, we don't want to move if we don't have to. So we're hoping that our concerns are addressed very shortly and in a timely fashion. And next, our internal audit. After 6 months, it has finally been completed. We've already implemented some of the changes that they have recommended. And as soon as the official report is out, we will be meeting with the medical board to complete the process. And that's my report. You want a
Okay.
break? The court reporter's here.
I have a question.
Yeah.
Assuming you stay in this building and the landlord's willing to make improvements, what's the time frame for these improvements being?
We're going to say 6 months.
Okay, thank you.
Because a lot of it has to do with security, and that's our concern.
Okay, thank you.
Okay, do we want to take a break to set up? Okay, I think at this point in time, we will take a break to set up for the administrative law judge hearing, which will start at 10 a.m. Thank you. I'd like to call the PA board back to order. We will now go to an administrative law judge hearing, and Judge Erin Koch Goodman is here to preside, and I will turn the meeting over to her.
All right, thank you very much. This morning, we are here before the Physician Assistant Board to review the petition for reinstatement of license from surrender of, pardon me for just a second, Ikate Daniel Udo. I hope I did that adequately. It is Office of Administrative Hearings case number 2017-120465, and it has been assigned a case number by the Physician Assistant Board of 950-2017-001638. As Mr. Sachs indicated, my name is Erin Koch Goodman, and I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter. What I'd like to do to begin today is start with introductions for the record, and if I could start at my far right with Ms. Early. If you could just identify yourself by name, please.
Sonia Early.
Thank you.
Xavier Martinez.
Jennifer Carlquist.
Jed Grant.
Robert Sachs.
Charles Alexander.
Javier Esquivel Acosta.
Mary Valencia. Very good. Thank you very much. We clearly have a quorum here present today. I'd also like to take appearances for the record on behalf of the state of California.
For the Attorney General's Office, Deputy Attorney General Jansen Tan, T-A-N, Tan.
Very good, thank you. And on behalf of Mr. Udo?
Kevin Murphy from Murphy Jones, appearing on behalf of the petitioner.
Very good. Prior to going on the record, I had discussions with both counsel, and we are going to begin today with a presentation by Mr. Tan on behalf of the state of California and a review of the petition that's been submitted by Mr. Udo. After that presentation of information and evidence and with an overarching statement for us, we will then have Mr. Murphy present equally clear an evaluation of the additional exhibits, and we'll identify for those for the record as we go as well. It is my understanding, Mr. Murphy, that Mr. Udo is going to be open to questions but is not going to be making a statement. Is that correct?
Yes, ma'am.
All right, very good. Nonetheless, if he's going to be answering questions, I'm going to start by swearing him in now so that we don't forget that for the record. Mr. Udo, if you could raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you'll give today or the answers you'll give to questions asked of you will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, very good. Thank you so much. With that being said, we will begin with Mr. Tan and an introduction of the petition, please.
Thank you, Your Honor. Members of the board, Your Honor, my name is Deputy Attorney General Jansen Tan, and I'm appearing on behalf of the Attorney General's Office pursuant to Government Code Section 11522. I'm here to assist the board in fact-finding. My role is not adversarial, but is intended to protect the public interest. I'm here to ensure that the panel has adequate information from which to make a decision. This is a petition from a stipulated surrender by Petitioner Udo. It is a petition for reinstatement. The burden of proof is on the petitioner, in this case, to prove the criteria for rehabilitation. You have before you an exhibit package, and I'd like to go through the exhibit package so as to save time and go through the background of this petition as well. On Exhibit 1, we have the petition for penalty relief by Petitioner Udo. Here he states that he was disciplined. The effective date of the order was May 26, 2011. This is the order adopting the stipulated surrender. The cause for discipline was that he was convicted of the felony count of gross vehicular manslaughter and driving under the influence of alcohol causing bodily injury and operating an automobile with a blood alcohol content of 0.08 or more. It was 0.13% at the time of conviction. Also in Exhibit 1, if you kindly turn to AGO page 3, we see the narrative statement by Petitioner Udo. Petitioner Udo is a Navy veteran with a rank of Lieutenant Junior grade, 13 years of active duty service. Upon graduation from the Navy, he partook in the master's program. It was a PA program and graduated in 2007. In April 12 of 2009, he was involved in an accident which resulted in the conviction. It was a car accident. The car overturned and tragically killed Mr. Udo's girlfriend at the time. He states that he remains deeply remorseful for this very tragic incident. He also wishes to state that he has had no prior history or incidents of drug-related or alcohol-related abuse or dependence. He served in the Navy with honor and distinction, and we will be able to review the numerous letters of recommendations from his commanding officer and other people that he has worked with. When he was sentenced in June 15 of 2010, he was sentenced to 4 years, 3 months in prison for the gross vehicular manslaughter and driving with a BAC of 0.13%. He served the sentence working as an inmate firefighter with the California Department of Forestry. He was released on parole on September 11, 2014, and discharged from parole around October 11, 2016. During his time at La Lima Conservation Camp. He also administered medical help to one of the inmate firefighters. He was commended for this. We're going to review it as part of the exhibit package, that he was fairly gallant and administered medical help, which shows his honorable service during the time that he was an inmate firefighter. We have an evaluation wherein he was diagnosed with alcohol abuse and adjustment disorder with PTSD resulting from his deployment to the combat zone in Iraq. He completed numerous classes, a substance abuse rehabilitation program, 12 months of neuropsychological testing. He also resumed psychotherapy counseling services from the Veterans Center in San Diego. We have numerous letters from that center as well. The next item that we have is Exhibit 2, which is the actual decision and accusation. The effective date of this decision was May 26, 2011. If you could kindly turn to AGO page 6, we have the start of the stipulated surrender and license order. The accusation is an attachment to the stipulation on page AGO 18. We have the first cause for discipline, that on May 11th before the Superior Court of California in the County of San Diego in the case of People versus Udo. Respondent entered a plea of guilty of 3 felony counts, specifically vehicular manslaughter, driving under the influence of alcohol, and driving with a BAC of over 0.13%. Exhibit 3, we have numerous reference letters. The first one we have from the Veterans Affairs. We have a second one and a third one as well from various military hospitals, and also from Mr. Udo's colleagues during his time with Chula Vista Vet Center. Exhibit 4, moving on, Your Honor, and members of the board. We have the Navy Substance Abuse Rehabilitation Program, completion of continuing care on page AGO 28. We'd like to note that the final diagnosis in this case on AGO page 28 was alcohol abuse and adjustment disorder with anxiety and depressed mood. Exhibit 5, we have the PA Board's model disciplinary guidelines. And Exhibit 6, we have the criteria, rehabilitation criteria, statutes and regulations with regards to granting or denying this petition for reinstatement. I'd like to note, Your Honor, and members of the board, that according to 16 CCNR 1399.526, on page AGO 00080, when considering the reinstatement, there are 5 general criteria to determine whether or not to grant or deny this petition, or grant in part and have conditions in terms of granting this petition. The first is the nature and severity of the act, the evidence of any act committed subsequent to the crime, the time that has elapsed since the commission of the act, the extent to which the applicant has complied with any terms of parole, probation, or any other sanctions lawfully imposed, and evidence, if any, of rehabilitation. Your Honor, members of the board, this is petitioner's first time to file a petition for penalty relief. And again, the petitioner has the burden of proof, so at this point, Your Honor, we would like to move the exhibit package into evidence, and we reserve the right to question the petitioner.
All right, Mr. Tan, if you could turn to Exhibit 4, AGO 28 for me. At the very top, it appears that Mr. Udo's social security number may be there. Is that right?
That is correct. That is an oversight, Your Honor. We will be filing a motion to seal everything at the end of this hearing, Your Honor.
All right. So there's a possibility of other personal information that's included in this packet?
There is a possibility, Your Honor. We would intend to seal the whole evidence packet, and that is an oversight, Your Honor.
That's all right. I just wanted to make sure that we redacted it if we weren't sealing the record. I'll allow you to make that motion at the end then.
And I have prepared an order as well, Your Honor.
Excellent, thank you. All right, Mr. Murphy, do you have an objection to exhibits as Mr. Tan has described them 1 through 6?
No, ma'am.
All right, so we will admit into the record exhibits 1 through 6, and with that, then, Mr. Murphy, I'll give you the floor to present. And as I'm sure you're aware, that the board has reviewed the documents that are that we've now marked and admitted at 1 through 6, and we've given them some time to take a look at the 2 additional documents that you've given them. But the focus today for the board will be on rehabilitation. And if you could take that as your note, I'll give you the floor.
Yes, ma'am. Thank you very much. Good morning. It's my pleasure to be here this morning representing Mr. Udo in this petition. As you heard, this case did arise out of a very serious accident that tragically ended in the loss of his then live-in girlfriend. Mr. Udo is a 47-year-old Nigerian-born physician in the country of Africa. However, when he came to the United States in 1995, we don't honor that medical degree. Shortly after arriving here in 1997, he joined the Navy, and as my esteemed colleague, Mr. Tan, indicated, it wasn't until 2005 that he enrolled in the Medical Services Corps PA program. He successfully graduated in 2007 and was stationed at the Navy Medical Center in San Diego, California. Mr. Udo then deployed to Iraq in 2008, where he was on the front lines that caused him to witness atrocities that many of us can scarce imagine. I'm highlighting for this board's understanding and consideration that it was only 3 weeks after returning from Iraq that this accident occurred. This was prior to any PTSD diagnosis or treatment. He had just returned. When he was in Iraq, he would work at the shock trauma ward. And in 2009, in your petition packet that you have, you'll see that he immediately voluntarily surrendered his PA license pending the outcome of his criminal case. Then in 2011, May 26, is when the surrender became formal because the criminal conviction was entered into the record. Mr. Udo has no other criminal record of any kind whatsoever. He maintains complete sobriety to this day. He hasn't had a drop of alcohol ever since the extremely unfortunate accident. Since that time, as we stated, he was diagnosed with PTSD and has been receiving treatment. He also had a diagnosis for the depression in relation to the loss of his loved one, Mrs. Flowers. He immediately took responsibility for his actions, and he began addressing his PTSD via treatment. As I stated, he maintained full abstinence and sobriety since the 2009 incident. He's successfully completed all criminal court requirements, and he was formally discharged from his criminal probation on October 10, 2016. As stated, he was a model inmate. During his incarceration and volunteered for the California Department of Forestry as an inmate firefighter. He was also, I don't know if it's a promotion or a lateral, but he also volunteered for the California State Water Resources Board as an operator in training. And during his incarceration, he participated in the Siddha Yoga Meditation Prison Project. In addition to his PA education, he has maintained that clinical competency, but he also got a paralegal certificate in 2013. He has 2 soccer coach licenses that he obtained in 2015. And in 2017, he graduated from California Western School of Laws, my alma mater, the Master of Advanced Studies in Health Law and Policy Institute. He also made the president's list in 2015 at Southwestern College as he was continuing his studies. In addition to the prison volunteer work, we have in our packet of documentation additional volunteer work. So he volunteers for the multiple sclerosis walk every year. He volunteers for the men's ministry at his church, First United Methodist in San Diego. He volunteers for the San Diego Blood Bank. While at Southwestern College, he was a health services volunteer, and he also volunteers for National Stand Down for Homeless Vets, which is a village in San Diego. I'm not going to read them to you. I trust the board will review the packet, but you're also going to see a number of military awards that he earned, and in my packet from 2005 up until the incident in 2009, and those speak for themselves. Mr. Udo hired me after he had originally filed his petition. That's why you're being presented with dual packets. So in our supplemental, what Your Honor is marking it as Exhibit A, I had 7 additional letters of professional recommendation, which when you read those, you'll see colleagues with full knowledge and awareness of the incident completely support Mr. Udo in recommencing his practice. They have full confidence that he has been rehabilitated and that he's learned his lessons and that he should be able to contribute back to society in his professional capacity. He's extremely remorseful, and he has learned a great deal from this accident. He's assured us that he's going to continue on his path of sobriety, and he wants to give back and start practicing as a PA while continuing to participate in the numerous volunteer services. Mr. Udo obtained 1 additional letter of professional recommendation after we had created our packets, which we brought for you today. An additional professional colleague, which you can review for yourselves. And in terms of the rehabilitation that Your Honor asked me to highlight, you will see as the second document in the supplemental mitigation packet is a letter from Mr. Udo's treating practitioner, David Quattrocchiocchi.
Can you spell that for the record?
Yes, ma'am. Quattrociocchi. Quattrocchiocchi. Okay. Which will also address his diagnoses, his current rehabilitation, his treatment, and his commitment to maintaining the sobriety that I mentioned previously. So in conclusion, we're willing to answer any questions that the board may have, or the Attorney General, and I believe that it's going to be your impression that after your consideration, it's clear that the petitioner is absolutely safe to practice again without any additional disciplinary action. But in the alternative, he's willing to do anything this board would order in order to recommence his practicing, any conditions of any kind. He just wants to start working in the career that he not only loves, but that he's extremely good at. And we'll adhere to any order that, whereby he'll be able to reinstate his license and recommence practicing. And with that, we'll answer any questions that anybody has.
All right, Mr. Murphy, let's just make a complete record. You had two additional exhibits. One is a fairly large, thick packet, about a half an inch, and we're going to mark that. The front page indicates in the matter of the petition for reinstatement. And then the second page talks about the supplemental mitigation documents and lists them. We're marking that as Exhibit A. And then we have the one-page additional letter of reference, and that appears to be from Clifton Butler, and we're marking that as Exhibit B. Is that correct?
Yes, ma'am.
All right, Mr. Tan, any objections to Exhibits A or B?
No objections, Your Honor.
All right, Exhibits A and B have been admitted into the record. Prior to going on the record, I asked Mr. Sachs whether he would like questions by the Attorney General's office first, and he said yes, so I'll turn the floor to you.
Thank you, Your Honor. Good morning, Mr. Udo. How are you doing today?
Good morning, Mr. Sachs.
First of all, we thank you for your service.
Thank you.
I have a few questions here. First off, in your petition, and I know that you wrote on your petition prior to engaging counsel, but I just wanted to make sure, I gave you an opportunity to address this. On AGO 2 of Exhibit 1, you were asked two questions. Question G asked you whether or not you became addicted or habituated to alcohol or drugs, and you answered no. Is that correct?
That's correct.
Okay. And question H is asking you if you've been hospitalized for alcohol or drug problems or for mental illness, and you answered no. Is that correct?
That's correct.
Okay, but I just wanted to clarify, you were treated for substance abuse disorder, correct?
I was treated on an outpatient basis.
You were
I
treated
wasn't-
for an outpatient basis, okay. So your understanding of this question is that when you say hospitalized for alcohol, what your understanding is that it was an inpatient treatment center?
That was my understanding.
Okay. I just wanted to clarify that. Also, in your narrative statement, Mr. Udo, on AGO page 3, third paragraph, lines 3 to 4, you stated that you were evaluated and diagnosed with adjustment disorder with PTSD resulting from your deployment to the combat zone in Iraq. Is that correct?
That's correct.
And that is accurate, correct?
I'm sorry, say that again?
That is accurate to your knowledge and
To
understanding?
the best of my knowledge, yes.
But if I turn to the Exhibit 4, AGO 28, I note there that the final diagnosis is actually not just adjustment disorder with anxiety and PTSD, but also alcohol abuse. Is that correct?
That's correct.
Now, was that an oversight on your part? The alcohol abuse. I noted that you did not list down alcohol abuse as part of your diagnoses. Was that an oversight in your narrative statement?
I believe so.
Okay. Moving down on AGO page 28, under program participation and condition upon discharge, do you see that line there, Mr. Udo?
Yes.
It states here that the patient's program focused on maintaining your abstinence and prevention of any further alcohol-related incidents. The patient, verbalized the treatment program, provided you with insight and awareness regarding how alcohol interfered with your life. Could you explain to the board what you mean by that, or what the program meant by that? How did alcohol interfere with your life?
Thank you, Mr. Stein. Members of the board. First of all, I'd like to say thank you for having me here and for this opportunity. In response to that question, Mr. Tan, I'd like to say that a couple of things have come to this whole experience has taught me. I've come to learn the true meaning of being honest and being humble. When I came back from deployment, I believe I was arrogant enough to believe that since I'd survived 2 prior deployments that I could weather whatever impact the 3rd one had on me. And because of that, I believe I chose to stay in a state of denial, which ultimately led to this tragic accident. One of my poor choices was resorting to the use of alcohol to numb the symptoms I was experiencing back then. So through the rehabilitation program, I was able to confront these issues and reflect, do a thorough and honest inflection. And I came to realize that alcohol wasn't doing for me what I thought it was. It was more of a debilitating substance rather than giving me the ability to recover my ability to function normally again. So that was the reason why.
I see. And we thank you for your candidness, Mr. Udo. I take it that you did have an alcohol abuse disorder, is that correct?
I was diagnosed with alcohol abuse. According to Navy criteria, I'd never had any incident. Actually, alcohol, I resorted to alcohol use as a coping mechanism.
Okay. I guess, what was your alcohol usage in terms of volume before the accident?
Are you saying prior to deployment or?
Prior to the accident.
Prior to the accident. In the evenings after work, I found it very difficult going to sleep. I couldn't use any medications because I needed to be clear-headed to work because I was still seeing patients. And my Marines depended on me. They looked up to me as a strength. I couldn't show weakness. So alcohol was more of a sedative. I used it to go to sleep.
Okay. Would you say that you were dependent on alcohol?
No, I wouldn't say so, no.
Okay. So, part of your sentence required you to go through an alcohol first offenders program, correct?
That's correct.
And you were also made to enter Alcoholics Anonymous program?
That's correct.
What is the date of your sobriety?
I'll say started from the day after the incident, which was, April 13th.
April 13th. What year?
Of 2009.
Okay. So, do you understand the importance of the date of your sobriety?
Very much so.
Do you know how important it is in an AA setting, how important the date of sobriety is?
I believe so, yes.
Isn't it true that in an AA program, in an Alcoholics Anonymous program, the date of sobriety is considered your birth date, your new birthday?
That's correct.
Are you aware of that
Very much so.
nomenclature? Okay. During the time of your volunteer or inmate program, rather, you treated someone. Could you tell the board more specifics about that incident?
Okay. Thank you.
I noticed that you received a commendation for that act. I'm trying to find it, but it's probably...
I was stationed in La Cima Fire Camp, and La Cima, Lacima,
Thank you.
in Julian. And it's not unusual that in between firefighting campaigns, inmates involved or engage in physical workouts to stay fit and to be fire ready. On one of our stand downs, one of the inmates, Oliver, I believe is his name, he was at the weight pile. That's what we call the weight room there. Oh, that's what it was called. He was at the weight pile engaged in physical workout. And so I was in the hostel reading some of my literature. And then all of a sudden I heard loud noises, people screaming, running around. Now, one of the inmates who I was close to knew a little bit about my background. He rushed into my hostel and told me, "Hey, we need your help. Somebody's having problems." And I rushed out to the weight pile, and he was on the ground in excruciating pain. And I immediately, without thinking, I just jumped in. And I asked him what the problem was, took a quick history, sent someone to go notify the camp commander, and decided to evaluate the problem. And I discovered he had an anterior dislocation of his right shoulder, which, as we all know, with such dislocations, the longer you wait, the more difficult it is to reduce it. So I believe the Good Samaritan rule would cover me at that time. So I just engaged in and went into manipulating, and 30 minutes engaged in manipulating the right shoulder. And about 30 minutes later, I was able to reduce it and stabilize him. And then we took him back to the hostel and applied a pack of ice. And the next day he was good to go.
And for the benefit of the members of the board, on page AGO 36 of Exhibit 4 and AGO 37, we have the reference letter of that incident and also the commendation. States that this selfless service reflects favorably on inmate Udo's altruistic character and dedication to teamwork, and that due to his actions, the timely intervention by inmate Udo facilitated return to full firefighting status of the injured inmate, with no loss of manpower hours nor medical expenses incurred by La Cima Conservation Camp. Moving on, Mr. Udo, what step are you currently, if any, in the AA program? Were you able to complete the AA program?
The AA program, from my understanding, because I did attend for upward of 6 months.
Okay.
In all honesty, and I hope I'm at liberty to be frank here, what I imbibed from that program was knowledge designed to empower people who believe they were addicted. Now, I'm not saying that the program doesn't have information or tool set for people who are who are having problems dealing with alcohol or who had incidents in the past. But after about 6 months, I realized that I had maximized on whatever the program had to offer me. I knew I am not an addict. But what bothered me every time I attended the program was people standing up and introducing themselves as an addict. To me, that form of positive reinforcement can stunt one's ability to step out of that zone. And I thought at that stage in my life, affirming that was in some ways going to impact me negatively. So rather than continue with AA program, I continued my counseling at the vet center, the group counseling.
Mr. Udo, do you understand that evidence of rehabilitation requires admission of the issues?
I am in complete admission of everything that I'm guilty of.
Do you believe that you had or have alcohol issues?
I completely agree that I did have issues with alcohol use.
Okay. What is your current support network?
Well, it starts with my family. My wife, my 2.5-year-old son, my 9-month-year-old daughter, my mother, my siblings in Nigeria and here, my colleagues in the Navy, the Veterans Affairs program, my counselor, which I have access to 24/7, and most importantly, myself.
And are you currently in therapy?
I have graduated from group counseling, but I have the ability to appear whenever I feel there's a need to.
Because I noted that you did suffer from PTSD, Mr. Udo. How do you handle stress currently?
I believe on a scale of 10, I am 9.5 in terms of being what I was before the incident.
Could you be a little bit more specific in terms of your coping mechanisms?
Again, my family is number one. My belief in a higher power, which I support with my twice-a-week yoga sessions, my studying, and my willingness to be competent enough to give back and assist people who are or may be in similar situation as I went through. So, I don't use alcohol anymore. I have no use for it. I have way too much to live for today, way too much. I don't experience the sleeplessness, the anxiety, the traumatic dreams. No, I'm able to watch movies these days without some memories disturbing my ability to function normally. So I would say that yes, I'm ready to get back to practice again.
Mr. Udo, after you're convicted and you entered into the first offender substance abuse program, was there any biological testing performed?
Yes, at the probation office, weekly testing was conducted, and that was all through the 2 years I was there.
Okay. So how long was that biological fluid testing for? 2 years?
Yes, for 2 years. Every week I had to submit a sample,
And
sometimes more than once a week.
okay. And you passed. You was
Never
no
had a
positive
problem
test.
because I never used anymore.
Now let's walk. Could you walk me through your volunteer activities, Mr. Udo? I note that you volunteered for MS walks and with your church as well, I believe.
Yes. Volunteering and giving back and assisting, I think it's the fundamental responsibility of every human being. We're not endowed with certain properties or abilities just to feel good about it. I believe we're endowed with these abilities in order to enrich the next human being, uplift the next individual. So for me, volunteering is it's a second nature. I've always done that prior to the Navy, in the Navy, after the Navy. So every opportunity to volunteer to help the next individual, I always welcome that.
So, the certificates that I have in the petition that I had beforehand list that you volunteered for the MS walk in the years 2015.
Is that a yes?
Yes, not just 2015, 2016. The only year I did not was last year, and that was because that time frame corresponded with when my wife was going through a lot. She was pregnant then, so I couldn't
And you also donated blood, it seems, to the San
Yes, I
Diego Blood Bank.
volunteered to the blood bank, donated blood
Do you still donate blood?
whenever I get the opportunity to. I haven't done that again in the last couple of years because of the events that's been going on in my private life.
And I note that you also completed your master's.
Yes, I completed a master's in health law and health policy at the University of California, San Diego. That was in June of 2017.
Could you tell us a little bit more about that program?
Sure. The health law, health policy program, I believe, is designed to educate and empower the individual to understand more of the tenets or the guiding principles of law and how it integrates into medicine. I needed to understand not only I needed to appreciate not only where I'd erred in my reasoning, but also to reinforce a need not to go down that path anymore. That's one. And two, again, my driving force has been to be able to use this experience to help the next person. Because I know a lot of service members are going through this, and either willfully or because of the system are in denial. And I'm trying to see what I can do to minimize that.
I see. Well, there's also an issue in terms of, obviously, you've been out of practice for a long time. Could you walk us through your CME continuing education and what you did to remain abreast of the current issues in your profession?
Thank you, Mr. Tan. I'd like to point out, make a little correction there. Formerly, yes, I have been out of practice, but I've never stopped practicing medicine. I've stayed on top of my studies, every opportunity to assist the next person. I have been engaged in that. I study using the USMLE World. I study using the JAMA. I review their journals, PA books, med law books. And because of my present position as the chronic care management director, I have to stay on top of the current guidelines because I review the charts of the mobile providers. So I am continually studying. I haven't never stopped. And this is all I know.
If you were granted a probationary license, for example, today, and with biological fluid testing, psychotherapy, an evaluation by a board-certified evaluator, is that something that you're willing to undergo?
I will be in full compliance of whatever the board sees fit.
Okay. If you were denied this petition, what are your plans?
That's a very interesting question. Up till now, again, like I said, my world has been in the service of the next individual, and the only way I've known how to is as a provider. I haven't seen any other thing. That's all I know. That's all I know how to do.
What would you do specifically?
You mean for employment?
For employment and
I'll continue as a chronic care management director at IHA.
would you try again? Would you file a petition?
I definitely will. If that's an option I'm granted, yes, I will.
And you will continue down your road of recovery?
I will. I have not deviated, and I don't see myself deviating.
If this petition was granted with conditions, what do you do? Or what are your plans
I will abide by the conditions.
In terms of employment, what are your employment plans if this were granted with conditions? Do you plan to enter the Navy, the Veteran Service?
Yes, first and foremost, I have to go back to what I know. The military's been very good to me, and I know the population in there are in dire need of somebody who understands what they're going through. So my experience would be first to enrich that population.
Okay. In terms specifically, did you intend to apply for the Veterans Affairs?
I have been in talk with the Veterans Affairs and with going back into active duty.
Okay.
So those options are still available to me.
I have nothing further, Your Honor.
All right. Mr. Sachs, do you have questions?
Yes. Thank you for your service. Are you currently certified by the NCCPA?
As a non-practitioner, actually, no, my certificate has been it was suspended following this incident. So I'm not really sure how to answer that question. I'm not certified at the moment, no.
Okay, because I mean, you took the original certifying examination
Right.
to get your license, and then you have to recertify.
To recertify.
every 2 years.
Right.
Did they take any action?
No, when I contacted them, they said that whatever the next step is going to be was incumbent on the decision taken by this board. Yes.
That's all the questions I have.
All right. Ms. Early, any questions?
I do. Just for my knowledge, you mentioned that, again, thank you for your service.
Thank you.
You mentioned that you completed the Navy-sponsored Master's in Physician Assistant Program. Where is that located? And
It's located in, there are two parts to it. The didactic, which is a year program, that's in San Antonio, Texas. And then the second part, which is the clinical, I completed at the San Diego Navy Medical and Dental Center.
Okay.
Here in Balboa, here in, I'm sorry, I'm still thinking I'm in San Diego. In San Diego.
Okay, great. Thank you so much.
Mr. Martinez?
I don't have any questions, but I just want to say thank you for your service and working with veterans.
Thank you, sir.
All right. Ms. Carlquist?
I second that. Thank you.
Thank you.
All right. Mr. Grant, any questions?
I do have a few questions. I'm also an IPAP grad, so thanks for your service, and perhaps have some insight that maybe my colleagues here on the board don't into your experiences during deployment. What is your discharge? I didn't find it ED 214 in your packet. Would you mind sharing what your discharge status was from the Navy?
I had 3 discharges in all. The first 2 were honorable. The last one was OTH, other than honorable, which I am in the process of having it reversed. And again, I'm waiting on the outcome of this.
Okay. And so if that decision were reversed, one of the things that you're considering doing is returning to the Naval Service as a PA, as a commissioned officer?
Correct.
Okay. Thank you. My next question is on your continuing medical education. I was able to find that you did about 50 hours in 2014 that were logged, and it's been 7 years since you graduated. I'm wondering if you feel, a little over 7, actually 8, do you feel that you're competent to see patients now? Do you feel you're safe to see patients based on your medical knowledge right now?
In all honesty, yes. Now, I'm not saying that I will not need some kind of step of training to get me back at speed. Patient care, in my understanding, I feel it's almost like riding a bicycle if you've been invested as much as I have. Now, I will not, if granted today, jump into patient care the next day. No, I will go through what is needed to get me back on speed. Because, of course, the safety of the patient is paramount. And I will not expose anybody to danger if I don't think I'm where I should be. Knowledge-wise, yes, I've kept abreast with the reading, but it's different when you translate that into actual patient care. Yes.
So the CME hours that you reported to us, what you're saying is those are the formal CME hours you did. Are you saying that you continue to study and do a lot more other studying besides the formal continuing medical education hours?
That's correct. The CME that I logged is from the American Academy of Physician Assistants. I do CMEs through Medscape. I do studying through USMLE World, through the VA medical portals, but not all those portals give you the option for CMEs. And to be honest, the CME hasn't been my motivation to study. I did this to make sure that at least I had proof that I was invested in my studies.
Okay. What would you say, so just to put yourself in a clinical scenario where you're treating a patient or a family member and they become aware of your background and your prior conviction and they asked you about it, what would you say to them?
I'll be very upfront and candid about it. I will forever carry that pain in my heart. The loss of a loved one, they say the pain gets better with time. I don't think so. So, to honor her, I'll give the best care out there. But I will be very upfront with my patients that yes, this is what I went through. This are the lessons I learned. It might help them. I don't know. But I'll be very upfront about it. And if they choose not to see me, then.
Okay. Just a couple more questions. I don't want to monopolize the time. Just wanted to ask you
Hey,
these.
Mr. Gregg, can I have a point of clarification?
Certainly.
If you look at our packet too, we have from 2017, the additional CEUs that he completed at a conference in Las Vegas. So-
At the 2017 AAPA conference? Is
Yeah,
that-
do you have those?
I do.
Okay, because I just heard 2014. I just wanted to make sure you knew. Since 2014, he's continued his studies as well.
Right. I probably wasn't clear in my question. Where I was trying to go was there's not a consistent every year, many hours, sort of hit and miss here and there. So,
Okay.
but he answered that. I think I understand.
Got it.
The answer there.
Thank you.
Didn't mean to be inaccurate. I'm sorry. So, if you go back to work, whether it's for the VA or in the military, particularly if you enter naval service again, it is likely that you'll be exposed to similar events that you saw in the past. I wonder if you have any concerns about working in trauma or being exposed to trauma and seeing some of those things that we see during deployment and things like that again.
To say I do not have any concerns would be a blatant lie. Yes, I do have my concerns, but I'm very confident that I'll be better equipped and better able to handle them because I now have a better tool set and I know that help is right there. And I have been able to, again, come to terms with two things, being humble and being honest. Even with these concerns, I don't see myself being a problem. I will practice competently. And if I need the help, I will seek the help immediately.
Okay. Yeah, thank you. That's all the questions I had.
All right, Mr. Alexander, questions?
Ms. Udo, again, thank you for your service.
Thank you, sir.
Did I hear that you studied medicine in Nigeria?
That's correct, sir.
And you obtained a medical degree in Nigeria?
That's correct, sir.
And how many years did you study medicine in Nigeria?
It's a 6-year program in my country.
And did you have a specialty when you completed?
I practice as a general practitioner, which is in the States, a family practice doctor.
And what brought you to the United States?
That's an interesting story. in my second year of practice as a general practitioner in Nigeria, I was awarded the U.S. lottery. And I thought that was a good opportunity to come to the U.S. and further my practice. And we all know that the system here is more advanced than that back home. And my hope has always been to acquire as much knowledge and tool set to be able to go back and help those who were in dire need back there. So I saw that as an opportunity to empower myself more, and I took it.
Did you make an effort to get a medical license in the U.S.?
Yes, and of course we're very aware that the hurdles are not designed to make it easy for any person not trained in the U.S. to break through. I did attempt the USMLE a couple of times, but I was shy of what the schools needed for the specialty I intended to pursue, and that was cardiothoracic surgery. And unfortunately, this incident happened a week prior to my next attempt at the USMLE exam. I don't know if that answers your question.
Would you say your medical training really helped you in the situation with the firefighter, the inmate firefighter?
Tremendously. Tremendously.
That's all I have. Thank you.
All right, Mr. Esquivel Acosta.
Just thank you for your services.
Thank you, sir.
All right, Ms. Valencia, questions?
No questions, and thank you for your service, sir.
Thank you, ma'am.
All right. In that case, Mr. Murphy, any final thoughts?
No, ma'am. I think that this presentation, Mr. Udo's character speaks for itself. His competency. It's a very sad situation altogether. But I think that it's clear he is situated to be safe in his professional practice in the state of California or anywhere where he would choose to try to obtain a license.
All right, thank you very much. Mr. Tan, any final thoughts?
Yes, Your Honor. I just wanted to, I guess in closing, try to assist the board in making their decision. The criteria for rehabilitation, as I mentioned before, is enshrined in Title 16 of the California Administrative Code, Section 1399.526. The first criteria is the nature and severity of the crime. The nature and severity of the crime was rather severe. It was 3 felony counts. The second criteria is the evidence of any subsequent acts, and we walked through numerous referral letters, positive interactions by Mr. Udo, specifically in the inmate program, also his attempt to keep abreast of the current medical landscape by taking all those CME classes. It's clear that that would weigh in his favor, that evidence of any subsequent acts would be in his favor, especially with his volunteer work. The time from which the conviction or the discipline has elapsed, the time that the DUI occurred was April 12, 2009. So time has indeed elapsed, although this is his first attempt to file a petition for reinstatement. The extent to which the applicant has complied with the terms of probation, he's completed all the terms of probation. We have glowing referral letters, recommendations. We can't really find anything negative in terms of Mr. Udo's file. Evidence of rehabilitation, I think he has shown that he has numerous referral letters and coping mechanisms. I do have one caveat. I did notice that in terms of the abuse, of the alcohol abuse, there is a little bit of reluctance with Mr. Udo's candidness in terms of the alcohol abuse. And when I asked him about the AA program, he struggled to remember his sobriety date. So I do raise some red flags in that sense, to the members of the board. If the board were to grant this petition, I do recommend certain safeguards for the public, and that's precisely why I'm here. If the board feels that Mr. Udo has presented enough evidence of rehabilitation, these safeguards would include a clinical diagnostic evaluation by a board evaluator. because his last evaluation showed that he has substance abuse disorder, also PTSD. We want to know where he is at currently in terms of coping with PTSD and the alcohol abuse. Biological fluid testing is also one thing that could be tacked on a probationary license, just to make sure the public is protected, that in the 2-3 years going forward, Mr. Udo does not imbibe in any alcohol drinks. In partnership with that, obviously abstaining from alcohol. We don't want to relapse, so that could be part of a probationary order as well. If the board has issues or concerns about his education, an education course can also be tacked on a probationary license. That would ensure that, as Mr. Udo mentioned earlier, he wants to be confident in his skills. So that would definitely help. With that, members of the board, Your Honor, I have nothing further.
All right, in that case, we thank you for your time, and we will take the matter as submitted with all evidence in the record. At this time, having just consulted with Mr. Sachs, we're going to go into closed session to consider this case, and so we'll ask for everyone to step out, please.
Including petitioner?
Yes.